Good afternoon, everyone, or good morning, depending on where you are. We're coast to coast today. My name is Jordan Alt. I'm a partner with Husch Blackwell in our Jefferson City, Missouri office, and I'm co-chair of our firm's nonprofit organizations and religious institutions team. If you're not familiar with that team, we have grown recently to almost 50 legal professionals across 12 of our offices, all of our business units that spend a considerable amount of our time working with clients in the nonprofit sector and specifically with religious clients. We consider ourselves a bit of a one-stop shop or a firm within a firm that we can bring whatever you need to our religious and nonprofit clients, from litigation, employment, real estate, all the way down to cemetery law, which is something I learned about recently. But we're glad that you're here. I'll show my bias. A lot of my work is with the United Methodist community and with the Missouri Annual Conference, so I'll shout out to all the Missouri Methodists on the call today. But before we begin, I need to go through a few housekeeping items and make a key introduction. You will see a number of icons at the bottom of your screen that you can use to interact throughout the webinar today. If you have any questions, there's a question box there. Feel free to submit those. We'll get back to you in writing, or Michaela and I will address your questions during the webinar. If we can't do that, we'll follow up with an email. I will answer 90% of your questions right now and tell you that a PDF of the slides is available in the program materials folder. That's always a question we get. This program has been approved for legal education hours. If you're attending live, you can click on the CEU icon to get a certificate of attendance. You'll get that tomorrow, along with a recording of the webcast. You can go back and watch it again, share with others. It makes a great stocking stuffer. And then at the end, you will be asked to complete a short survey. Please take the time to do that. We read everything. A lot of the webinars that we do, and we do 3 or 4 a year, are based on the input that you provide. So like I said, I have an important introduction to make. I am joined today by Michaela Hennessy, who is a colleague in our Kansas City office. She's a labor and employment attorney with a nationwide practice dedicated to monitoring, advising, and representing employers on local, state, and federal laws affecting the employment relationship. She works with a lot of churches and nonprofit entities, including a lot of my own clients. And I know they would join in saying that she brings not only a lot of experience and expertise to the process, but in working with religious clients, also a lot of grace, which is fantastic. And it's been great to work with Michaela. I'm glad that she agreed to help out with this presentation today. By way of background and in full disclosure, I should tell you who you are. I thought we might get a few dozen people for this, and we had well over 300 attendees sign up, which kind of shocked me. I'm glad you're here. About half of you work at religious colleges, universities, schools, or seminaries. About 40% of you are clergy, administrative professionals, or lay leaders at faith communities of all different denominations and religions. 10% of you, I apologize, I'm putting you in the everything else bucket, which would include nonprofit employees, for-profits with an interest in the topic, current former colleagues at Husch Blackwell or other firms, just here for those sweet, sweet CLE hours. Regardless, I'm glad you're here. There's a great line from Ted Lasso where he introduces two people and says, congrats, you both just met a cool person. And looking at the list and knowing what I know about your ministries and your mission-oriented work, I'd say the same about a couple hundred of you. Real quick, because there are so many of you in a university setting, you may have some questions about something our Labor Relations Law Insider blog has posted about recently, which is about the NLRB possibly expanding its jurisdiction over colleges and universities with religious affiliations. I will tell you up front, I know enough about labor law to know that I should not address that topic. It's a bit outside of the scope of what we're addressing today. However, our labor team is aware of that. If you're here today, you should be signed up for our nonprofit mailing list, and you'll get some updates about that. But if you're interested in a webinar about something like that, put it in the survey at the end. All right, let's get started. You're stuck with me for the next 15, 20 minutes or so talking about the so-called ministerial exception, which I think will be important to a lot of you. I'm going to address not only the cases, but a little bit about the facts of the cases, because so many employment decisions are so fact-intensive. From there, you will be lucky. I will hand you off to Michaela, who will discuss state and federal statutes and how and when and why they apply to religious employers. And then the meat and potatoes of the presentation, Michaela is going to walk you through the considering the law section, which is really kind of a list of best practices and recommendations for the employment cycle, from hiring to oversight to discipline to the end of that employment relationship. So I'll get started to talk a little bit about the ministerial exception first. I promise not to go into too much legalese. I know there are a lot of lawyers on the webinar today. Not all of you are. I do need to at least have you read the first clause of something that I hope you're familiar with, which is the U.S. Constitution and the First Amendment to the Constitution, and the two religion clauses in the First Amendment. They state, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Together, those are called the Establishment Clause, which means that essentially the government can't favor a specific religion or any religion at all, and the Free Exercise Clause, which states that a government can't interfere with an individual or an entity's ability to exercise whatever religion they choose. To borrow a phrase from the Supreme Court, there's a lot of play in the joints between the Establishment Clause and the Free Exercise Clause, both of which come into play when we talk about the ministerial exception. I will tell you, there's a lot of text on my slides. I'm going to go through them pretty quickly, but I wanted to include a lot of this information so you have it in the materials at the end. But don't feel like you need to read everything super quick. The ministerial exception comes from both the Establishment and Free Exercises clauses. And essentially what it means is it's a way of shielding religious organizations from judicial review of internal employment disputes regarding the selection, control, and removal of employees designated as ministers. Now, that's a lot of words to basically say civil courts, stay out of the process. If you are hiring, disciplining, terminating the employment of anyone that you consider a minister or that the courts would consider a minister, that is up to you. Because of the First Amendment, the civil courts should play no role in that process. Now, you may think, well, this clearly goes back hundreds of years, but really it doesn't. The primary case, if you study this, comes from 2012, the Hosanna Tabor case. A lot of you may have seen that. I'm going to go through a lot of the facts of these cases. So in it was before 2012, it involved a teacher called Cheryl Perrick. Ms. Perrick was an elementary school teacher at an evangelical Lutheran church and school in Michigan. She was hired as a lay teacher, but later received a diploma of vocation designating her as a commissioned minister, and she became what was in that faith background called a called teacher. So in addition to the regular reading, writing, arithmetic, she also taught religion classes. She led students in prayer and devotions. She attended and sometimes led a chapel service at the school. Ms. Perrick developed narcolepsy and went on disability leave. When she came back, she learned that the school had hired a new lay teacher. They didn't want to continue her employment. And the congregation, and from my faith background, this seems a little unusual to me. I'm not used to this, but the congregation had a meeting and they voted to offer a peaceful release from her call. They would pay a portion of her health insurance premiums in exchange for her resignation. Ms. Perrick said no. They terminated her. She filed a complaint with the EEOC alleging she was terminated in violation of the Americans with Disabilities Act due to her narcolepsy. And the EEOC filed suit against the church and school, claiming that she was terminated for threatening to file a lawsuit pursuant to the ADA. Now, the church filed what's called a motion for summary judgment. I won't go into the legalese, but essentially it's a way for a party to litigation to say, court, even if you assume all the facts are true, that the other side says is true, we should win under the law based under this ministerial exception. And the court agreed. They appealed to the Sixth Circuit, which is a federal appellate court that looked at this and says, no, the ministerial exception doesn't apply here because Ms. Perrick is a teacher. She's not a minister. And the Supreme Court, it's called granting certiorari, the Supreme Court agreed to hear that case. Again, there's a lot of text here, but it's pretty important. So the Hosanna-Tabor court said, since the passage of the Civil Rights in 1964, appellate courts have recognized the existence of a so-called ministerial exception that basically precludes the application of anti-discrimination legislation to the employment relationship between a religious employer and its ministers. And here's the key language. The court says, we agree that there is such a ministerial exception. Requiring a church to accept or retain an unwanted minister or punishing a church for failing to do so intrudes more upon a mere employment decision. It violates both the free exercise and the establishment clauses. So the court said, the ministerial exception exists and it applies here. And importantly, they said, it doesn't just apply to the head of a religious congregation, it applies to Ms. Perrick. But they frankly kept attorneys like us employed by saying, we're not going to give you a rigid formula. It's going to be fact-based, but based on the facts that we have, it's clear Ms. Perrick is a minister and the ministerial exception applies. The court basically gave 4 key circumstances to consider. And they said, well, Ms. Perrick was held out as a minister, she had religious training, she had a formal process of commissioning, and her job duties reflected the role in carrying out the church's mission. So fast forward about 8 years, we had another case that got a lot of press called Our Lady of Guadalupe School. So it's a slightly different court at this point, and slightly different facts. Agnes Morrissey Baru worked at a Catholic primary school as an elementary or middle school teacher, 5th and 6th grade. She was a lay teacher, but she taught all subjects, including religion. She attended some religious education courses, but not many. She attended faculty prayer, but she didn't lead prayer. There was a faculty agreement about the Catholic nature of the school and said teachers were required to lead prayer and take students to Mass and communion, which she did. Ms. Morrissey Baru was terminated. The school failed to renew her contract, and she filed suit under the Age Discrimination in Employment Act, which protects employees over the age of 40. Michaela will tell me if I'm wrong there. And she basically said, I was being terminated so the school could hire a younger and likely cheaper teacher. So the school moved for summary judgment. It was granted under the ministerial exception, but the Ninth Circuit, which is historically one of the more progressive or liberal appellate circuits, reversed. And they said, this is completely different than Hosanna-Tabor. Ms. Morrissey Baru did not have the formal title of minister. She had limited formal religious training. And critically, she did not hold herself out to the public as a religious leader or minister. And for what it's worth, Ms. Morrissey Baru testified that she was not even a practicing Catholic at all. This was not unanimous, but the Supreme Court took it up, and in a 7-2 decision with Justices Sotomayor and Ginsburg dissenting, the Supreme Court expanded the application of the ministerial exception beyond ministers of the faith to also include lay teachers who were entrusted to educate students in their faith. They basically said that Ms. Morrissey Baru played a vital role in carrying out the mission of the church, and therefore she should count as a minister, and the ministerial exception should apply. In addition, and this is critical, the court basically said, yeah, we gave you those 4 factors in Hosanna-Tabor 8 years ago, but really what matters at bottom is what an employee does. Again, the court declined to adopt a rigid formula and instead decide the cases before it, as it expects lower courts to do. The very next year, and Our Lady of Guadalupe basically opened up the floodgates to a lot of this type of litigation, as Hosanna-Tabor had done several years earlier. The Demkovich versus St. Andrew the Apostle Parish was decided in 2021. Now, I will note this is not a U.S. Supreme Court decision. This came out of the 7th Circuit Court of Appeals. This was out of Illinois, and it involved a man named Sandor Demkovich, who was hired as a music director, choir director, and organist at a parish in Illinois. He was terminated 2 years ago. He filed suit claiming that he was discriminated against based on his sex, sexual orientation, marital status, and also because of his disabilities. Mr. Demkovich is a gay man. During the time of his employment, he became married to another man. His supervisor told him that that marriage was against the teachings of the Catholic Church and asked for his resignation. He said no, and he was terminated. In addition to that, Mr. Demkovich suffers from diabetes, metabolic syndrome, and weight issues. He claimed that he was subject to belittling and humiliating comments based on those conditions that had nothing to do with his employment. Basically what he said is, my supervisor, Reverend Dada, is making fun of me constantly because of my weight. Mr. Demkovich originally sued under Title VII of the Civil Rights Act and the ADA. That was dismissed under the ministerial exception, but he filed an amended complaint and changed it and said, wait, I'm actually filing a new case saying that I was subjected to a hostile work environment based on my sex, sexual orientation, marital status, and disability. This gets into some legalese, but a split panel of the Seventh Circuit ruled against the church, allowing all hostile work environment claims to proceed. It then went to what's called the en banc, all of the justices of the Seventh Circuit considering this. And they looked at that and they ruled that the ministerial exception precludes any inquiry into the reasons behind a religious organization's ministerial employment decision, regardless of the type of claims at issue. The court said if the relationship between a church and its minister is its lifeblood, then the relationship between its ministers is its backbone, which is very flowery language to basically say it doesn't matter what the claim is, including hostile work environment, and including hostile work environment claims where there's no religious justification to defend the alleged conduct. Basically what the court says is, under the ministerial exception, religious employers shouldn't have to defend anything at all. They shouldn't have to give any religious justification to the decisions they make. Now, there's one other case that I want to address, plus a bonus case later. That's the Faith Bible Chapel versus Tucker case. It's up before the Supreme Court right now, and actually the justices are meeting in chambers to discuss it as we speak, which was just a fluke. I promise I didn't plan that. But basically, for the lawyers on the call, the court is being asked to consider whether the ministerial exception provides an immunity from judicial interference or just a defense, whether the application is legal or factual, or whether denial of a motion to invoke the defense is appealable. Basically, in layperson's term, what that means is if you get sued and you invoke the ministerial exception defense and you lose, what's the question before the Supreme Court is, do you have to go through the discovery process and depositions and a trial, or is that all completely improper for a civil court to consider? Like I said, we'll know more about that in a few months. Based on recent holdings from the court as it currently stands, my assumption is that the court will say this is an immunity, not just a defense against liability, but we'll see what happens. All of this goes to a common issue. A lot of church clients ask me, hey, can we do this? And if we do this, will we get sued? And the answer is always, yeah, you can do this. Yeah, this is legal, but that doesn't mean you won't get sued. People sue for anything, even if the ministerial exception applies. And that's something you need to calculate for in making employment decisions, which Michaela will talk about in a little bit. So what are the three questions you should ask to determine whether the exception applies? Number one, are you a religious organization? Michaela will look to statutes to define this in a little bit, but generally it's going to include churches, synagogues, mosques, but also schools, hospitals, retirement homes. If the mission is marked by clear or obvious religious characteristics. Now, one note, I've been involved recently with some formerly religious colleges and universities that have chosen to essentially sever those ties and become secular institutions. And courts have said that the ministerial exception doesn't apply to, for example, a hospital that severs its ties with the United Methodist Church and becomes secular. In other words, if you take that step to move from a religious to a secular employer, this exception won't apply. Second, is the employee at issue a minister? You need to consider the Hosanna Tabor factors, but also what does the employee do? And courts have expanded this to include music ministers, teachers, librarians, school principals. Now, for those in the higher education context, a case that you should be following is Gordon College versus DeWeese Boyd. This actually came out of the Supreme Judicial Court of Massachusetts. It involved a professor of social work who was required to sign a Christian statement of faith involving religion issues. The professor taught completely secular classes and claims that she was denied promotion to full professor based on her opposition to the school's views regarding LGBTQ+ students. There were cross motions for summary judgment. The trial court ruled in favor of the professor, and the Massachusetts Supreme Judicial Court upheld that, concluding she was not a minister. Now, this was appealed to the Supreme Court, and the Supreme Court denied cert, which means they decided not to hear the case, which in some cases you may assume meant they were okay with the result from the the Massachusetts Supreme Judicial Court. I don't think that's the case here. It was very unusual in denying cert. Justice Alito, joined by 3 others, and if you're a court watcher, you probably know who they are, Thomas, Kavanaugh, and Barrett, filed a 6-page statement saying, although we're denying cert, we may be required to resolve this important question of religious liberty, and talked about the troubling and narrow view of religious education. My assumption is these justices are basically saying, hey, religious schools, we're going to rule in your favor. We just need to get the right case in front of us. Again, that's the law according to Jordan, not the Supreme Court. But I have a feeling if you read that 6-page statement, you'll probably agree that that's where they're going. Finally, third, is the activity itself protected? As we've seen, the answer is probably yes. And that would include hostile work environment claims, even sexual harassment claims. So one last slide as I figure out, or finish up. What does this mean for you? Now, a lot of it is going to depend on the ruling in the Tucker case to determine what this litigation looks like going forward. But a few other considerations. First, consider the pushback about the exception, essentially restricting the civil rights of church employees. I've done a lot of trainings on this, and oftentimes religious employers are excited to hear about this exception. Religious employees, however, when they find out that a lot of anti-discrimination statutes don't necessarily apply to them, aren't quite as happy about it. Something you should keep in mind in your relationship with your employees. Even if Tucker goes, as I think it will go in front of the Supreme Court, being on the receiving end of a lawsuit is still an expensive, time-consuming, and emotional process. Michaela's going to give you a lot of guidance for how to avoid that. And even if the ministerial exception is a defense, we always advise clients, you essentially assume it isn't. Do everything you can to not get hit with one of these lawsuits. And Michaela will help tell you how to do that. A victory in court does not mean a victory in the eyes of the public, particularly if it becomes public, and litigation like this will shine a spotlight on your decisions. And you make a decision against someone based on what would otherwise be a protected class. Well, other members of that protected class might not be as happy about that, whether they're in your congregation, on your faculty, on your student body, something to consider. And finally, because I know I'm speaking to a lot of faith-based organizations right now, just because something is legal does not mean that it is right. In this context, and working with many of the clients on this call, I have a lot of conversations about not only what is legal or proper, but also what's ethical, what's morally acceptable based on their theological background, their spiritual teachings. It's something to consider that just because you have the ability to do something for legal and spiritual reasons doesn't mean that it's the right thing to do. With that said, I am really excited to pass this along to Michaela, who's going to walk through a couple state and federal statutes and then also provide some really good suggestions on how to avoid this type of litigation. Michaela?
First, good morning and good afternoon, everybody. Hopefully you can all hear me all right. Jordan, thank you for providing that helpful background on the ministerial exception. Unfortunately, as Jordan was hinting to, not all employees will fall under the ministerial exception. In fact, many employees won't. As such, religious employers should try to comply with all statutory provisions, which Jordan also got at on the last slide. These provisions stem from state, local, and federal laws, which we'll look in turn. Based on these statutory provisions, we'll also get into best practices to try to avoid that costly litigation. So first, there are many statutory considerations, and we could have a full week's worth of presentations on all of these statutes. But let's just briefly go over some of the key federal statutes at first. Title VII, as Jordan was mentioning, prohibits gender, race, national origin, and religious discrimination, harassment, retaliation. The ADA, as also Jordan mentioned, prohibits age discrimination, and this is applicable to individuals 40 and plus. So Jordan, you were right. Your employment knowledge was coming out. The ADA is the Americans with Disabilities Act. The Americans with Disabilities Act prohibits discrimination, harassment, retaliation for individuals with disabilities. We also have the Pregnancy Discrimination Act, Equal Pay Act, GINA, which is Genetic Information Non-Discrimination Act, and this prohibits discrimination on the basis of genetic makeup. We also have USERRA, which is Uniform Service Employment and Reemployment Rights Act, and this prohibits discrimination, retaliation, harassment against military personnel. With that being said, we need to address the caveats and the nuances of state laws and local laws. All of the states, unfortunately, have codified their own protected classes, and we'll get into that as well. Let's focus in on Title VII first. Title VII makes it unlawful for any employer, a religious employer especially, to fail to refuse to hire or to discharge an individual or discriminate against the individual with respect to their compensation, terms and conditions, and privileges of employment. And this is based on those protected classes, so gender, race, national origin, and religion. However, there is an exception, and that is religious organizations and religious educational institutions. Religious organizations and religious institutions have been defined by the courts as institutions whose purpose and character are primarily religious. However, the Congress has not intervened since 1970. And with Congress not intervening, the courts have been required to determine when an entity is primarily religious. The Department of Labor, the Equal Opportunity Commission, and the courts have all defined many different factors to determine when an organization is a religious organization. Some factors courts consider include day-to-day operations, such as if it's a house of worship, or if it's an organization who provides services to individuals without homes. The courts will also look at articles of incorporation. We'll get into a topic later on, but some articles of incorporation specifically state that the organization is meant to serve and act as a ministry. They will also look at if the organization is affiliated with a specific religion. And for our educational clients, they'll look at the curriculum. What is being provided to the students and what curriculum is being required? No single factor is dispositive, and all factors have been analyzed by the courts. Unfortunately, the analysis, as I said, is split. The courts will look at all different factors depending on all of the facts of the case. The courts have found under Title VII that religious organization applies to churches, houses of worship, religious schools, hospitals, and charities. Recently, the Ninth Circuit actually held that an organization entitled World Vision International, which was a global humanitarian organization with Christian ties, was considered a religious organization. However, in contrast, the Louisiana Federal Court in 2020 actually found that a mission organization was not a religious organization under Title VII because it was not affiliated with a particular denomination. The organization's mission held that it desired to change lives and lead people to Christ. The Articles of Incorporation also said its purpose was to provide Christian ministry. But other factors, including no specific religious affiliation with the church, with the denomination, with a synagogue, weighed against finding that the Downtown Mission Organization was a religious organization under Title VII. Therefore, their acts, they couldn't rely on the religious exemption that comes under Title VII. Religious organizations can prefer to employ individuals who share their same religion. This is where the exemption takes place. And this includes the employer's religious observances, practices, and beliefs. But this exemption under Title VII is not absolute. Religious employers who do classify as religious organizations cannot discriminate against employee on the basis of any other protected class. I wanted to throw this example up there to go over. And this actually comes from the Third Circuit in 2006. A female employee taught at a small Catholic college. The Catholic college required all employees to agree to adhere to the Catholic doctrine. The Catholic doctrine at this time was against abortion. The female employee, however, signed a pro-choice advertisement in a local newspaper, and her name was published. The college terminated her employment after seeing her name in support of the pro-choice advertisement. They terminated her employment because it violated their doctrinal beliefs. The female employee sued the college for sex discrimination, alleging male professors were treated less harshly for other conduct that violated the church doctrine. And I emphasize other conduct. The court ultimately held that this did not violate Title VII. The Catholic college was allowed to terminate the female employee because she did not have the same beliefs as its Catholic doctrinal beliefs. The exemption of Title VII preserves a religious organization's ability to maintain a community composed of individuals faithful to its doctrinal practices. Let me circle back to the emphasis on other. Here, the court specifically found that the male professors did not engage in the same activity as the female employee. Specifically, some of the male professors had outwardly made public statements about not agreeing with America entering into a war. This public support for one topic differed from the female employees' support for a pro-choice advertisement, according to the court. And they said they were not comparable. Therefore, the Catholic college could take two different actions. This analysis, though, would be very different if the male professor had also publicly made a statement in support of the pro-choice advertisement and was not terminated. We quickly went over the federal laws. And again, there's many more nuances to those federal laws, but let's jump into the state-specific laws that all employers, including religious employers, must be cognizant of. Local and state laws are not uniform. And local and state laws, honestly, keep me employed. They're the ones that I advise on a day-to-day basis. With regard to the employment laws, the states and localities can truly craft how the definitions and how these statutes are framed. We see this when they define the term employer. We also see this when they define protected classes. So for example, some states and localities have different protected classes which employers cannot discriminate, harass, or retaliate, such as natural hairstyles. That has been a recent statute that has been going across the nation. Since I'm currently located in Missouri, let's first touch on the Missouri Human Rights Act as an example to show the difference in state laws. Under the Missouri Human Rights Act, employers does not include corporations and associations owned or operated by religious organizations. This means that an employer who is a corporation and or association within Missouri cannot be successfully sued under the Missouri Human Rights Act. Though the Missouri Human Rights Act, however, does exclude religious organizations. This does not mean that federal anti-discrimination laws do not apply. So employers still must be cognizant of the federal statutory provisions. We see a different approach in Colorado, for example. Though Colorado also defines employer to exclude religious organizations, it does have a caveat. Employers do not include religious organizations or associations except those organizations or associations supported entirely or partially by taxes or public borrowing. So it's not as clear as the Missouri Human Rights Act, but it does have a caveat for religious employers. Unlike Missouri and Colorado, you have other states who do not have a caveat for religious organizations, such as New York. New York does not exempt religious organizations under their state anti-discrimination laws. California also does not exempt religious organizations under their state anti-discrimination laws. And Wisconsin's similar. As you can tell, the states all vary based on their definition. And for employers who have employees in different states, your remote employees, all of these considerations must be made before you enter into that employment relationship.
Michaela, if I can interrupt, we got an interesting question, and now seems like a good time to interpose it. And that question is, what is your view on mandatory employment arbitration agreements with respect to religious organizations? Michaela, I'd be curious about what you think. Basically, from what I can tell, I haven't seen many of them, because for what it's worth, as I see it, the ministerial exception does not prohibit an arbitrator from considering the applicability of these statutes, or from adjudging an award, the same way that it would prohibit a state court from doing so. Generally, however, though, mediators, arbitrators, others are likely going to be aware, or can easily be made aware of, the ministerial exception. But for what it's worth, pushing these employment disputes into private arbitration agreements may weaken a little bit the reliance that religious employers may have on the protections of the ministerial exception. Michaela, I'll turn it back over to you to either continue, or if you have any other thoughts on that question, either way.
No, Jordan, I would agree with everything you said. I would echo that. To me, the arbitration agreement wouldn't be as effective, but it's definitely going to be tailored to each client as well. So we've looked at the statutory provisions, and again, we are just doing a very high-level review of those federal and state laws. For some attendees on this call, you deal with the hiring, firing, and disciplinary actions on a day-to-day basis. So some of this may be a little repetitive, but it's always good to hear the best practices. While other attendees on this call, which I have spoken with directly, rarely handle these concerns. And so it's always good to be able to hear a high overview of how we address the life cycle of an employee. Today, while keeping in mind all those statutory provisions, we will discuss best practices for employees as applicable to the life cycle of an employee, from the hiring stage to the oversight stage to the end of an employment. Before you jump into the hiring stage, I recommend that the position that you're hiring for have an accurate, up-to-date job description. Having a thorough, well-developed job description can ensure that you understand what you're seeking for and in a well-qualified candidate. Written job descriptions should include the list of qualifications, the necessary skills, the non-essential and essential job functions. It should also include education and experience. I recommend to employers often that they review job descriptions on a periodic basis to ensure accuracy and update the position as needed to conform with the changes in the organization. Job descriptions truly are the basis for a successful hiring and life cycle of an employee. Job descriptions help provide clear guidelines for recruiting. They also provide objective measures for evaluating the employee, and if you have to take remedial action. After you have that good job description typed up and ready to go, it's time to move into the application process and opening that up to the public. Before you get started in the application process, it's always good to review your application for employment. We recommend that all applications have an at-will language provision where the candidate acknowledges that this is an at-will employment, if it is. And at-will employment generally just means that either party, the employer or the employee, can end the relationship at any time. The application should also have an acknowledgement section for the candidate to sign and execute that all information included in the resume and application is truthful. If an employer is also wanting to get references, have a release form attached to the application. Be cognizant, though, of those statutory provisions. You don't want to include questions on the application that violate some of those statutory protections that employees are afforded under federal and state law. Another incident that I just was thinking about over the past week or so is really ensuring that applicants complete an application. And I know that's something that you are probably thinking, well, Michaela, of course we would have them complete an application. I just spoke with an employer within the past week where they just got a resume and they called it good. If for some reason this employment relationship ends up in litigation, you want to be able to tie to objective criteria. In an application, a resume is tying it to that objective criteria. Let's talk about the interview and assessing the applicant. This usually takes place in an in-person format or virtually nowadays as well. You're really trying to assess the applicant based on objective criteria. So experience, training, education. Again, you're not considering those protected statutory classes such as race, age, sex. Document your interview. It's always good to have those notes. And again, if for some reason this employment relationship breaks down in the future, we're able to go back to our notes and say, this is why this candidate was hired. This is why this candidate was ultimately passed over. Avoid those pitfall questions. This is where you see attorneys jumping in more often. Avoid those questions based on age, sex, race, disability, and all those protected classes. However, because it's a religious organization presentation, religious organizations, if properly classified, can prefer candidates with the same religious views. And we'll get into some of those questions. Here are some of the common pitfalls we see in interview question, and I have to say I've seen all of these throughout my practice. And these are just recommendations for how employees can better ask the same question and get to the same information. These three pitfalls come from disability inquiries, age inquiries, and marital children inquiries as well. So instead of asking about disability-related conditions, have the employer ask about the job applicant's ability to perform specific job functions that are listed on the job description. Again, this all goes back to the job description. So, for example, if the job description states that a candidate, an employee, must be able to lift 40 pounds, specifically state that. The candidate should be able to stand for 2 hours, state that. Ask the job applicant if they can perform those job functions. Don't ask about the age or their date of birth. Rather, just ask if they are generally older than 18 years old. Also, this has been talked about more recently, especially in the Me Too movement that's been going around. Don't ask applicants about if they have children or if they plan to have children. Rather, to get to kind of the same information, ask the applicant if he or she has commitment to responsibilities that prevent them from regular or timely attendance. Get to the meat of the meat of the question. Here are 3 other pitfalls that I have seen as well, and this is related to national origin discrimination, military service discrimination, and religious discrimination. Employers should not be asking about whether the applicant is a citizen, Rather, they should ask if that applicant can submit proof later on upon hiring. I've also heard where an employer has asked for military service records. Instead of doing that, you can simply just talk about whether the applicant has served in the armed forces. And for my non-religious organizations, they should not be speaking about the applicant's religion. But for those who are properly classified as religious organizations, they can ask questions about the applicant's religious beliefs, doctrinal views. So for example, the Methodist Church can ask whether the applicant is a practicing Methodist and would be able to fulfill these needs. At the end of the day, the hiring process is all about being clear, concise. Take each step as it comes. After you run through the interview, notify the candidates of the decision, whether they have or have not received the position. Then draft up the offer letter. And just as we've discussed, the offer letter should also be concise and clear and tied back to that job description. It should list the expectations and duties of the position. Regarding onboarding, there are many considerations employers must analyze to ensure that the employee is properly trained and fit for employment. Importantly, I want to quickly touch on handbooks and policies. This in and of itself could be a full weeks-long CLE regarding how to draft the best handbooks and policies for your employees. But let me just quickly touch on some key points. Handbooks and policies should very clearly express that the employer is an equal opportunity employer. It is following state, local laws. This comes back to our federal and state laws. So if you are a Missouri organization and you're headquartered in Missouri, you have an employee up in New York, you have to consider the protected classes that New York considers. Handbooks and policies should also define how complaints should be raised and addressed and how the organization will take remedial action to address those complaints. With that, let's turn to the complaint process. We've gone through hiring a fantastic candidate. The candidate's performing excellently. Within a year, though, the candidate raises some complaint. The candidate states that the employee states that he or she is, feeling left out, treated differently, or felt uncomfortable by some interaction. That is a complaint. Complaints can arise through various sources, from the alleged victim, from a third-party witness, or anonymously. We also have seen them through demand letters between attorneys exchanging letters between each other, or through the administrative charge, the EEOC, the Missouri Human Rights Act, and any of those state agencies. We also see them through lawsuits. When an employer receives notice of a complaint, the employer has a duty to investigate the complaint. This is required by federal and state law. Recent trends by plaintiffs' attorneys specifically in litigation tend to focus in on failures to properly investigate. How the investigation is handled from the very get-go can mean everything if the matter does end up in litigation. Let me quickly note that complaints do not need to be in writing. I advised an employer recently. The employer had in their handbook that all complaints should be in writing. The employer said, well, the complaint wasn't made in writing, it was made in passing. It was a pretty serious complaint. With that being said, they said, do we have an obligation to investigate? My first words were yes, you have a duty to investigate. Under the EEOC, which is the Equal Employment Opportunity Commission, they specifically state that employers are obligated to investigate no matter what form or means that complaint is made. Importantly, as well, there are no magic words that a complaint has to use. So the complainant doesn't need to say, I was discriminated against, or I was harassed, or I was retaliated. As you saw as I mentioned previously, a complainant can simply state that he or she felt they were treated differently or there was an uncomfortable interaction. These can rise to a complaint that needs to be investigated. The investigation process is pretty in-depth. Once the employers receive an investigation, the employer should immediately take actions. Waiting on responding can also be the focus of a plaintiff's attorney's case when these cases do go to litigation. I could spend an entire day with you talking about how best to conduct these investigations. But overall, these are some of the quick steps that I recommend for all employers, including religious entities. We recommend that the employer immediately confirm receipt of the complaint and state that the investigation will occur. The complaint should be directed then to the proper internal channels. In most cases, for some employers on this call, that's going to be your human resource department. They are trained to spot these complaints, to address these complaints, and next steps. However, for some of my smaller entities that I've advised and who are on this call, they may not have a dedicated human resource personnel or department. So that could be the executive pastor who takes on that responsibility or a hiring manager. It depends on your entity. Either way, follow company policies and procedures. So if in past it was the executive pastor who's done these investigations, have the executive pastor again conduct these investigations. After processing the complaint, I usually want to speak with the complainant. During this conversation, this is very important to assure that the complainant, that he or she will not be retaliated against for bringing forth a complaint. Retaliation can form the basis for legal liability under local, state, and federal law. Retaliation simply means that an employer took action after an employee engaged in protected activity. And protected activity can include raising complaints. Also, employers should never promise confidentiality, complete confidentiality at that. And this practically makes sense. During the investigation, the company will want to speak with witnesses and other people. Therefore, promising complete confidentiality is not realistic, especially when conducting a proper investigation. After speaking with the complainant, I usually gather those documents and identify those witnesses. Once you're talking with those witnesses, during those interviews, try to ask open-ended questions and then ultimately get to the specific allegations. While you're there, I also recommend asking for supporting evidence. So I've seen in the past where fact witnesses will say, well, yeah, we discussed this via text message. I have the text messages here. If the employee is willing, ask the employee to share those text messages or those social media messages. Gather that evidence at that time if the employee is willing to share. There are often times, though, where witnesses do not want to cooperate. They don't want to get involved in company drama or don't want to get involved in this investigation. When I get these calls, I will ask the employer, do you have a provision stating the witness must cooperate? We recommend, if you do not already have this in place, that all employers insert in their employee handbooks or their policies that witnesses should cooperate with an investigation conducted by the employer. If the witness fails to cooperate and answer questions, the employer can discipline the employee for insubordination. Just wrapping up and concluding the investigation, ensure you just tie the loop. Show your documentation, show your reasoning. If applicable, identify the rules that were broken and state the remedial measures to be taken. Tell the individual who complained, tell the alleged wrongdoer if any remedial actions will be necessary. Again, documentation is key to show, if litigation does arise, that you addressed and properly investigated and took action in regards to this complaint. Lastly, sometimes complaints do lead to termination, or unfortunately, employers have to make the hard decision to let an employee go. Recently, as I've been advising through the termination process, I've been getting questions, especially for my smaller entities and my smaller religious entities specifically, who the decision maker is. Common question I get is, well, can I terminate this employee without anyone else's approval? And my response is, it depends. I know that's not the answer most people want from their attorney, but unfortunately, that's the fact. Set policies and procedures, again, decide who the decision maker is and who can make those termination decisions. If it's not in writing, follow prior procedure. Another key consideration and topic I discuss with the employer who's calling to discuss termination is ensuring that all company property is accounted for before the termination meeting is held. This includes not only tangible property, but also passwords to accounts, and considering whether the employee has access to credit card information, and ensuring that the company is taking all necessary procedures to protect itself. During the communication of the termination, ensure that a witness is there, and that witness is really charged with documenting the termination and ensuring that how that conversation goes about is documented in paperwork and held into files later on. Again, tie the termination to company policy and how the individual violated a company policy. I know I quickly went over the life cycle of the employment relationship, and hopefully you took away some key best practices. If you guys have any more follow-up questions, I know we're running up against time, please reach out to us and we'd be happy to answer them. I'm going to turn it back over to Jordan now to close this out.
Thanks so much, Michaela. You did a great job. There's just enough time for us to answer some questions and too little time for us to answer the really tough ones, which is that sweet spot that we like to be in. I'm going to address a few of them round robin super quick right now because there have been a couple common themes. One is about contract rights. What is the ministerial exceptions impact on contract rights, including, for example, tenured faculty? It would be great if the Supreme Court ruled on that. They have not. There's cases that you can find going either way. Generally, it seems that most cases are saying that the ministerial exception applies towards anti-discrimination statutes. If you have a contract that is something other than just employment at will, there may still be a viable claim under that. That may change in the future based on how the Supreme Court comes down, but we'll see what that looks like. Another question, how strong must the religious characteristics be within an employer? Essentially, a court is going to be very hard-pressed to question the bona fides, in other words, of a religious organization. They're not going to dig too deep to determine whether you are really a religious organization or not. Michaela gave a few considerations that courts may make, but I think courts are really only going to question that in very extreme cases. They've done it, for example, in the past where so-called religious organizations seem to just be a way to funnel donations to private political parties. If that is too blatant, the courts may get involved, but that's going to be pretty rare. Let me see. Let's do one or two others. Michaela, I will kick a question to you if you're willing to do this. What are some examples of phrases you might use if an employee requests confidentiality in bringing a complaint and you don't want to offer that?
Of course, so we've seen this often. Again, I would recommend to not promise confidentiality, but state that you will do your best to keep it to the individuals who need to be aware of the complaint and who need to be involved in the investigation process. At the end of the day, to really fully investigate that complaint, you do ultimately have to bring in outside witnesses or sources.
The other thing that I'll add in all that is sometimes, particularly in religious environments or in higher education or schools, some of those complaints involve claims that may need to go to state agencies under mandatory reporting requirements. If there are claims, for example, of sexual abuse, you need to be very careful about making any promises if you are a mandatory reporter, and may need to turn around and make those hotline calls to raise those issues. There are a small number of other questions that we'll try to reach out to individually, as well as some notes of thanks. Thank you for that. I appreciate it. But looking at the clock, I'll go ahead and close us out today. Again, as a reminder, we hope this has been helpful. It has been approved for legal education. To report your hours, click on the CEU icon at the bottom of the screen. You'll get a certificate of attendance and a recording of this tomorrow. Watch it as many times as you'd like. Send it to your friends. And finally, be sure to complete our short survey. If there's anything that you'd like Michaela and I or anyone else from our team to discuss in the future, let us know. We're happy to get the band back together. Thank you so much for your attendance today. I hope everyone has a great day.